are the states told by the study group at any point that, look, in lieu of your taxing revenue, what is it that you require by way of total revenues to be generated, so that we will take royalty, fixed royalty, take into account your overall loss of taxing revenues? Does that exercise happen? We find only that they have said, well, to cushion the payment of DMF and NMET, the reduction of rates of royalty in certain cases has been recommended. Because after the 2015 amendment, they have to pay to the National Mineral, the District Mineral Fund and the Exploration Trust.
Yes, District Fund.
Right. But is there anything here to indicate that the states are told that, well, what is it that your revenue generation requirements are?
No,
and therefore, when we fix the royalty, we will take into account your loss of tax revenues.
I get that. My questionnaire, questionnaire which is sent to the government, state governments. Lord, page 148, if your lordships can come to, Lord. Para 6.4.
You are right that throughout the study report, the study group's report, they keep on saying that, look, we have to cushion the impact of the DMF and the NMET.
Meaning
but
is
that really right? Therefore, you are because of the DMF, the states are getting this additional levy. The industry has to pay extra, so that we will cushion that impact by reducing the rate of royalty.
So, meaning thereby nothing else. Otherwise, there is no question of cushioning. Yes, even they are going to the extent.
Nothing else is the key. See, where do you get that actually?
I'll not come to that. But just answering your lordship's question.
Because we saw that everywhere they are saying to cushion the impact of DMF, NMET.
If your lordships are looking at a specific negatively worded provision, there is none. That nothing else, this and nothing else, because legislature do not use such language, my lord, for another legislation, a negative language. They occupy the field, and I'll show the field is occupied.
Only to the extent provided.
Exactly. I'll show the extent. Your ladyship is right. I'll show to what extent it is provided.
In fact, the provision appears to be to compute the effective rate of tax. The effective rate of tax is the total amount which is paid to the state, divided by way of royalty and other levies, divided by the total realizations on account of sale. Then they say that the effective rate of tax is very high in India, and therefore perhaps the royalty rates have to be so modulated.
That would, in my submission, necessarily mean that if you put any other burden, the balance at the national and international level will be disturbed. That's the only similar. Answering my lord, the Chief Justice's query, Lord, please come to PDF 136. Criteria for determining royalty rates. Lordship gets it, madam. The Lordship gets it. Can I read? Lord, kindly come to F and G. F. Lord, I'm not reading the rest.
But see B, for instance, impact of high burden of taxation, especially in comparison to international mining jurisdictions. So does this not really therefore seem to contemplate that there is a duty to pay tax to the states? The burden is high.
No.
And therefore we are fixing the royalty to modulate the burden of taxation.
No. The impact of high burden of taxation would mean that as per the global phenomena, our fiscal regime, I will not use a use a neutral word, that our fiscal regime has high taxation. But therefore, my lord, I have shown to your lordships what it includes and what it doesn't include. My lord, please for a second, my lord, just to answer, my lord, come back to, my lord, that high taxation part. Value of
Mr. S.G. query of
Means that
Honorable Chief Justice was
yes.
very fact that clause B refers to high burden of taxation,
Yes, sir.
it itself contemplates that states will continue to levy taxes.
My lord, I am
That will be
answering.
taken into consideration while fixing the royalty.
Correct. My lord, I am answering that.
Right.
My lord, please come to 19. 132, my lord. 131, I'm sorry. 131.
As you rightly said,
May I answer that, my lord, possibly?
royalty, though fixed by the union, is entirely appropriated, levied and appropriated by the states,
Correct.
right? Now, therefore, when they are fixing royalty, they are fixing the price which the states will realize for the extraction of minerals of which they are owners, right? That's the whole concept of royalty. Also of dead rent, that because you don't extract, you have to pay dead rent. Now, while fixing the royalty, which is a realization by the states for the extraction of minerals, the study group looks at what the state is already realizing on account of taxation. And it in fact says that because there is such a high burden of taxation which the states are imposing, therefore we will modulate the royalty accordingly, which postulates again that taxation is something which the states are imposing. In fact, it's not the other way. That look, we are increasing the rate of royalty to a level so that you will exclude all other levies.
Can I
That's
answer
not the
that?
approach
Can I
of the
answer
study
that?
group.
But there is an answer. There are two answers. Please come to, my lord, page 131 at the foot. 131.
Nor are they fixing royalty to compensate for the loss of tax revenues.
It's there, my
it's
lord.
a reverse.
I'm showing that. My lord, if your
Page-
lordship can just bear with me. Page 131.
131.
131. My lord, how, my lord, the effective tax rate is calculated? 131 bottom. Lordship gets, my lord?
Yes.
Value of all amounts paid to the government by the minor.
Mr. Solicitor,
Only a minute.
this goes against you.
No.
If the numerator in the effective rate of tax were to be the value of all amounts paid to the government on account of royalty,
No.
then you would be right.
No. Kindly, my lord, kindly, my
When
lord,
they
give me a minute.
they factor in all payments which are made to the state.
We try and read, my lord, it that way, but kindly read it other way. That everything which the,
And because
no, one thing is clear.
because the product of this division, the numerator and the denominator, is so high in the case of India, almost 60%. Therefore, they wanted to impose a more realistic royalty regime by, in fact, reducing the rate of royalty.
Can I answer that one? Can I answer? Oh, first and foremost, when this report is prepared, Kesorami holds the field, and therefore there were levies. There are levies. So that cannot be ignored by the study group. Correct, my lords? After Kesoram, the state is imposing levies in some my lord, states. It's 500% of that of the royalty. So it says value of all amounts paid to the government. Please, my lord, now turn the page. That would get, my lord, the answer, my lord, of what my lord, the Chief Justice, my lord, put.
India 59 and 60.
59 and, my lord, that's okay. But note, what it does not include. First, he said everything which is paid to the government, but except this, my lord. Please see, ETR, that is effective tax rate, does not include a number of other payments such as auction price, purchase of land for mining, GST of 18%, 10% tax levied by the Supreme Court, net present value in case of survey, net present value, compensatory afforestation, upfront payment at the time of grant of mining lease.
But it therefore does not exclude the state cesses. It includes the state cesses.
That's exactly
right?
what
You
I'm
may
saying.
be right, it's because of the prevalence of Kesoram. Because when the study report came, we were in the Kesoram regime,
Yes.
where the states can levy cess. But the fact remains that this study group postulates that the rate of royalty would be so modulated so that the amount which is realized by the states towards royalty is adequately reduced to factor in the high rate of taxes which the states are otherwise imposing.
My lord, would your lordships come to a 2-page thereafter, my lord? 5.9. There are 5.9.
Methodologically, the study group is not saying that, look, We are now going to give you an adequate realization by way of royalty so that you do not impose any other levies. That's not what they are telling the states.
Other hand, this-
136,
this
if your
this
lordship comes.
exclusion clearly states that there are other types of exactions
Right.
which the states can do. For example, in Karnataka, forest development tax or FDT is levied on forest produce, which also includes mineral resources.
So that is the question, my lord, whether it can be levied or not. That's the question. Whether it can be levied. But that's the question. It is levied. My lord, in every state, under some name or the other, it is being levied. But my lord, my reading of, my lord, this page 131 is that how tax rate is my lord, derived, all whatever you are supposed to pay, state tax, royalty, district fund, national fund, everything, multiplied by this, except A, B, C, D, E, which does not in the exceptions or deductions do not take care of state. And apropos your lordship's query, my lord, please come to page 136, whether it is considered or not, that what is your revenue requirement. Point G, my lord, I stopped, my lord, at 5F, but please see G. Implication of revision of royalty rates on revenue realization of the state government and the industry. This is inclusive.
From royalty. That's right.
But my lord, there are always two ways of reading it, my lord. But, my lord, what they say is that what will be the implication on the overall growth of, my lord, this sector and how it would impact. My lord, if I don't, my lord, wish to take your lordship through every mineral, my lord, wise discussion, what they say is this is the total amount which a miner pay. This mineral is used in ABCD industry. This is the position in the global market. And if we do not put the cap of total fiscal payment at particular point, it would be against the development of the mining industry. That is how, my lord, they have proceeded. Lord, the difficulty for me is
सीमेंट जो उस समय ये regime प्रोसेस नहीं लगा था. States were compensated through
Lord, after, Lord, Lord, I'll come to the act immediately.
B.
Lord,
B and G also.
Lord, after, Lord, I'll come to the act immediately. But apropos this query, my lord, after India Cement, when the state was not permitted, my lord, to levy anything other than royalty, they were compensated by the respective study group by increasing royalty. So it is always considered as a composite receipt by the state. Lord, please, my lord, come to volume 5, only one paragraph, page 1569. Lord, this is a Mahalakshmi judgment. State of MP versus Mahalakshmi Fabrics. So when you are not levying the other charges, you are compensated.
Volume 5, right?
Yes, my lord. Volume 5, page 1569. It starts at 1561, my lord, but I am pointedly inviting your lordship's attention to the relevant part. PDF is 1575. I'm sorry, 1575. 1575. Left side PDF.
1567.
1 5.
Lordship gets, my lord. Left hand side, my lord, pagination 1575. PDF pagination. My lords, my lord, get it, my lords?
Yes.
The Lord, first, the controversy ultimately came to be decided by this court in Orissa Cement versus State of Orissa, whereby such cess was held to be invalid and beyond the legislative competence of the state government. It appears that soon after the aforesaid invalidation of the cess, the coal-producing states were faced with problem of refunding the amounts obtained by them that far. They therefore approached the central government for help. In pursuance to the said approach, Parliament passed an act validating the cess so that they don't have to repay it to the government, repay it to the miners. We are not concerned. We are not concerned with the said ordinance and subsequent act in the present proceedings. It appears, please note this, that since the state government had suffered financial losses because of the invalidation of cess, they also approached the central government for help in the matter. As a consequence thereof, a working group was constituted in this behalf. The said working group suggested an increase in the royalty to the extent of 17% per ton of coal. The working group also found sufficient justification for compensating the coal producing states to the extent of 100% of the loss caused by the aforesaid judgment of this court. Since the recommendation was accepted by the central government, the impugned notification was issued by the government according to the writ petitioner before the High Court. The increase in the rates of royalty pursuant to the notification was to the extent of 400% to 2000% as compared to the royalty fixed in 1981 on various varieties of coal. It was further contended, etc. My lord, the point I am making is, when they were prevented from taking any levy, that loss was compensated in the fixation of royalty. And when they are, my lord, now permitted to levy because of Keshav Rao and subject to what your lordship decides, my lord, the royalty is so fixed that it also takes into account that you are already earning this much. Because this subgroup, my lord, cannot sit in appeal whether it is leviable or not. They will have to proceed that as on date it is leviable. You are earning 100 rupees.
In other words, the fixation of royalty is not agnostic to what the states are realizing by way of taxation.
Because of Keshav Rao. Yes. Yes. Therefore, my lord, therefore this reference.
It doesn't that the states are entitled to demand something by way of tax and they adjust the royalty every 3 years.
Now, my lord, what would happen, in practical terms, what would happen? If your lordships hypothetically were to hold that the state had no jurisdiction, competence, state legislature had no competence to levy a particular levy other than royalty, dead rent, and my lord,
You are saying that the government of India will increase the royalties. If you are,
because that will, somewhere we will have to have a national perspective. Lord, we will have to have national perspective, keeping in mind the global scenario, and this exercise cannot be left to the provincial interest. Narrow provincial interest. Narrow, I'm not using it in a bad sense, but when I'm deciding for one particular state, my lord, my examination would be a narrow examination. I would not take a holistic national approach, and in any case, I cannot take global factors into consideration.
side. See, if a state is so foolish as to impose a tax at such high rates, obviously the market will provide for greater imports.
Yes.
If there is a greater amount of imports, the states will lose their revenue because there will be no demand for locally produced minerals.
My lord, the nation loses, my lord, when import increases.
Right.
That's exactly what, my lord, I am driving at. That if the domestic production is less because of high taxation, the import starts. That's what we are, my lord, avoiding. We want, only give me a minute, my
The
lord.
state will never want to be in a situation where by overpricing overtaxing the product, it starts losing its revenues. Because if it overprices the product, it's also a matter for demand and supply for the state. If it overprices the
Yes,
tax
happened.
rates, if it overcharges, then obviously there'll be a greater incentive to import, as you're rightly saying. In which case, it will impact upon the state revenues.
My lord, sometimes suppose they undercharge it. They undercharge it and start exporting. Lord, the idea is that on the national level, a holistic decision is taken that our minerals, which are our national resource, are used for domestic production of infrastructure and core industries. And therefore, this is one way of controlling import or export.
So it's just one, what you are trying to show is exercise done once
No, every 3 years it is done.
Yeah, it's very slightly different.
I'm sorry.
We are not considering how the royalty is being fixed by the central government. We are considering only a very simple issue, whether power to impose royalty is itself sufficient to draw an inference that states are denuded from the power under.
Please come to
850.
the act, my lord.
Yeah,
No,
and
please come to them. I know, my lord. That's the heart.
Because
of the-
suppose in a given case, tomorrow central government says that we want to impose royalty of say only 10 rupees. They have power to impose royalty of 10 rupees. So can you say that the states can't levy the tax? In a given fact situation for a particular year, the government may have undertaken this exercise of talking to the states, taking their feedback. We are really on the question whether only because there is a power to levy royalty, the power
Only
of the states to levy
factually-
taxes is.
I'm answering
externally.
that immediately. Factually,
Right.
look, this is not a one-time exercise. This is an exercise done whenever there is a revision of royalty. That is every 3 years, sometimes for not 5 years. So this is how the section 9 is read. The consultation is read into section 9. That is one. The consultation with the state to arrive at a consolidated figure is read into. Now please see section.
Time lag. Public interest in rapid growth doesn't happen.
Metaphorically, just taking from what Brother Oak was
My lord, my respectful submission, giving, my lord, taking the example, my lord, metaphorically as your lordships are taking.
for example,
If my, yes, sir. My lord, if my intention is to occupy it exclusively, then he is ousted. My lord, apropos my lord's concern, and a very valid concern, that market forces can itself arrive at a particular decision making. For example, your lordship said, give me a minute, my lord, to answer, that state if overcharges, then state would not get the revenue and therefore market forces would ultimately, my lord, settle down the issue. Lord, that takes a very long time. When we rely upon market forces to settle down an issue, the damage is done. And this is damage about our national resources, and damage would be national level. My lord, the mistake would be, or whatever decision would be of a state. My lord, your lordships are examining this as a federal issue.
To use Brother Rishikesh Roy's example, your submission is that, look, because I am occupying my chair, Dr. Singhvi is ousted from occupying his chair.
No.
Go ahead,
I'm
sir.
sorry, my lord, I'm sorry. Only a minute.
That's why I said what lies.
No. I'm sorry, my lord.
No, that is why I said what lies.
My lord,
beyond
I would answer, my lord. My submission is, there is only one chair in the room which I am occupying with an intention of ensuring that nobody else, including Dr. Singhvi, occupies the chair. There are no two chairs here. Your lordship, my lord, example presupposes two chairs. I am saying, my lord, there is entry 54. 50 says, if there is a law under 50, you are out. So there is a law under 50, the field is occupied. And there is only one field. That is mineral development and regulation and development of minerals. So, my lord, my metaphoric example was when there is only one chair and I occupy the chair with an intention of excluding others. And I am giving, my lord, why I gave all this, my lord, because I have to show public interest. It's not, my lord, just that state center wants to act like a big brother. There is a public interest involved, my lord, as entry 54 stipulates. My law is not just, my lord, for development and regulation. To oust or to be treated as a limitation, it must be in public interest also. That's what I was showing. That why this has to be done at a national level and not at provincial level with some narrow considerations weighing. And your lordships are right, my lord. Sometimes a wrong decision by a state to overprice may damage the state, and after 3-4 years, the state may come down. But what happens within that 3-4 years? That's the question, my lord, which will have to be asked.
See, one other perspective is in the context of royalty, the Central Act or the Parliament is permitting the states to levy royalty. But what is the limitation imposed on
No,
the
not
levy?
levy.
No.
Parliament
they are
doesn't permit me to
no,
levy.
it is the state is levying the royalty under the Central Act.
No, my lord. What
It's not the center which is levying the royalty.
I am only fixing the rate.
Correct. That is the only limitation on the right.
No. My lord, my
fixing of
submission
the
is, now examine that submission. Examine that submission. My submission is,
Royalty, the states are.
state,
So Parliament is enabling the states to collect royalty,
yes, not,
but the
yes,
limitation is only on the rate of royalty.
correct.
So that is a constitutional limitation in the context of entry.
That is their submission that the
No, under the act.
that's, my lord, I have to yet, my lord, convince your ladyship. But their submission is that section 9 is the only limitation, and since section 9 does not prohibit other levy, we can have law providing for other levy. But that submission is wrong, my lord. That's what, my lord, that's the main dispute.
Yeah, you are going to go to the act now, I suppose.
Yes, kindly, my lord. My lord, kindly come to the statement of objection reasons. Differentiation made between petroleum and other minerals in item 53 and 54 of the union list has rendered separate enactments for the two necessary. The present bill deals only with minerals other than petroleum. At present, both are dealt with under the mines and minerals, my lord, that is the old act. In my lord, your lordships can skip, my lord, nothing would turn. Come to, my lord, the preamble. An act to provide for what, my lord? Development and regulation of mines and minerals under the control of the union. So the act provides that the entire act take within its control the development and regulation. Whatever is necessary for development and regulation of mine is now under our control. Your ladyship is right. Section 2 says to the extent below. I am conscious of it. 2. Declaration as to expediency of the union control. It is hereby declared that it is expedient in public interest, to borrow, my lord, expression from entry 54, that union should take under its control the regulation of mines and the development of minerals to the extent hereinafter provided. Now, my lord, it provides for three things. Lord, first is reconnaissance. Lord, I want to, Lord, show that entire universe, so far as mineral regulation and development is concerned, is now covered by this, and therefore there is an occupied field. Lord, reconnaissance would mean without touching the soil by, Lord, satellite imaging or whatever, one would first decide whether there is any mineral in the land. Second would be prospecting of mineral. So there is a prospecting license regime where you excavate just to find out whether there is any mineral. Sometimes you are trying to find out a mineral and you find B mineral. There is a provision made. Then you have to surrender your lease and give it to the government back. If, my lord, instead of uranium, my lord, something else is found. And third is actual mining. All these three. There are two separate chapters under the Act, one dealing with regulation of mines and another dealing with development of mines. And my respectful submission would be that these two chapters, read with other provisions, Lord, I've started with the act, my lord. Can I start after lunch, my lord? It's 5 minutes.
All right.
So that one continuity, my lord, your lordship can take.
How long would you now take, Mr. Solicitor?
Lord, one more session, less than that, my lord. But I'll,
We have given 1 day for everybody to conclude, actually.
my lord, we have relied upon your lordship's kindness.
All right.
And
But I think
there is a
everybody should
rule of estoppel.
Everybody should conclude by lunch tomorrow. I think that will be a very fair, isn't it? By
Lord,
lunch tomorrow, everybody
Lord,
now.
we rely,
Tomorrow. By tomorrow. We have to close tomorrow
No, Lord.
because we have regular.
my lord, I would say something. My lord, we are before a 9 judges bench. Any lacuna on our part in assistance, my lord, ek minute. Even for the other side, my lord, I would request that if there are 2 counsels, let both give the.
And one more thing, I am going to be doing without prejudice alternative arguments. Your lordship accepts these arguments, the matter ends.
Well, your
Lordship doesn't
Lord,
accept.
your lordships would,
Not
my
going
lord,
to-
my lord, what your lordships would, my lord, give it to
After
me.
now the Solicitor General concludes. I think everybody can take 20 minutes each and then.
Lord,
because it's
Lord, I would
more of-
invoke, my lord, I
more of
would.
a good thing now, I think.
Lord, I would invoke the doctrine of legitimate expectation and estoppel. Your lordships cannot cease to be kind.
Very good, right?